If you are considering bankruptcy, we will provide you with all the information related to it and how you can file for bankruptcy. This video is specifically curated for people like you who want to understand the basics of bankruptcy and the process that goes behind it. Bankruptcy is a life-altering decision and can stay on your credit report for up to 10 years, so you better make an informed decision. But before you learn all you need to know about bankruptcy, pay attention to the big red subscription button. As soon as you click it, you will be taken to the wealthy side, the life you deserve, where you'll find hundreds of videos. These videos contain the answers to almost any question you may have. There are also daily updates, so if you want to stay tuned, remember to turn on notifications. Bankruptcy is a legal procedure that allows a business or a person overburdened with debt to eliminate some or all of the debt and start fresh, or work out with creditors to pay the debts more manageably. It is mostly filed by a debtor, but creditors can also file it under some circumstances. The legal team analyzes the assets of the debtor and sometimes uses them to repay the debt. The debtor is an individual who owes the money and files for bankruptcy, hoping to get some relief from debts. A creditor is a bank, business, or individual who lends money to be returned in the future. During an ongoing bankruptcy case, the creditors cannot ask for debt payments or sue the debtor. Also, creditors cannot claim the debtor's future income or future assets. Bankruptcy proceedings. The U.S. Bankruptcy Code governs all cases of bankruptcy. A person or a company files a case in the federal courts. A federal bankruptcy judge makes all the important decisions, like which debts can be eliminated or whether the debtor is eligible or not. At the end of the bankruptcy case, a debtor is discharged from debt involving the legal team, and creditors are offered some form of repayment. Important personnel, other than a judge, is the trustee who administers the case on the whole. The United States Trustee Program of the Department of Justice appoints a trustee. When you file for bankruptcy, your assets come under an estate managed by a trustee. The trustee's role differs based on the case. Whether to hire a bankruptcy attorney is optional and depends totally upon the personal preference of a debtor. A bankruptcy attorney is someone who guides you through the whole process. Preparation to file can be quite overwhelming and arduous for some, and I'd say it is sensible to hire someone who knows the procedure and help you make better decisions. The Bankruptcy Code. The U.S. Bankruptcy Code, or Article 11, is a set of instructions for individuals and businesses who filed for bankruptcy. The United States Bankruptcy Code expects everyone to follow these rules strictly while filing for bankruptcy. Although the major role of bankruptcy is to clear debts, different types of bankruptcy codes deal with different situations. Chapter 7 is the Liquidation Code, and Chapter 9 helps protect the municipalities. Chapter 11 is for business reorganization, and 13 helps plan the repayment of debts. Chapters 12 and 15 deal with farmers and foreign cases, respectively. Chapters 7, 11, and 13 are the most commonly used codes, and we're going to focus on these three here. Chapter 7. Chapter 7 bankruptcy is considered the default bankruptcy for many people as it is the most common form of bankruptcy. It is relatively quick and efficient, but the debtor has to be a business entity. It has to be either a sole proprietary or a partnership. In exchange for debt relief, a debtor has to transfer property to the trustee. Some properties can be kept exempt, like their primary residence, car, furniture, 401k plan, and disability benefits. A trustee collects the non-exempted assets of the debtor. His task is to sell the assets and pay the creditors. It is also called straight bankruptcy, and the trustee is allowed to make decisions. So, when you file for Chapter 7, the court orders an automatic stay on your ongoing debts. This ceases any action by creditors, like collecting payments or possession of your assets. As mentioned earlier, the court assigns a trustee to deal with your assets. It takes 4 to 6 months to complete the procedure, and at the end of it, you don't need to pay debts anymore. Moving on to Chapter 11. Chapter 11 is primarily available to corporate entities and is used to reorganize a business. A company may declare bankruptcy under Chapter 11 without liquidating or shutting down the operations. It is important to note here that companies who file for Chapter 7 are way past the stage of reorganization. So, those filing for Chapter 11 are hoping to continue the operations and make the business profitable again while paying the debts. We hope you understand the difference here. Let's move on. Businesses filing for Chapter 11 have to come up with a plan as to how they will pay their debts while continuing to operate their company. The creditors and judges have to approve this plan to go further with it. The petition filed by the debtor is voluntary or involuntary, which is filed by the creditor. In Chapter 11, a company tries to rehabilitate the business while managing finances and paying debts under legal supervision. The job of the trustee here is to supervise the assets and keep the business running. Now, what you need to know is that in Chapter 11, the debts are not discharged. Rather, they are restructured by changing the terms of payment. After 120 days, a debtor is asked to give the reorganization plan outlining how the debts will be paid. This plan must get accepted by the judges. Otherwise, the debtor won't be able to proceed further. However, if the company cannot complete the plan, they have to file for Chapter 7 and liquidate. Chapter 11 is a bit complex and expensive among all, so a business should carefully analyze other options before choosing it. A quick reminder, if you've enjoyed the video so far, consider subscribing, as we frequently upload such informative and educational videos. Let's continue. Chapter 13. It is called a wage earner's plan, essentially because the debtor has to have a regular income to devise a repayment and reorganization plan rather than liquidating the assets. The debtor gives a complete plan detail on how he will pay the trustee, who will then distribute the cash among creditors. Chapter 13 plan is pretty rigid regarding the debt limit and the time window. The court approves the plan only if there is a reasonable chance that the plan will be successful and compliant with bankruptcy rules and regulations. The debtor is bound to pay debts in 3 to 5 years. It works for people who want their assets safe and want to buy time to deal with foreclosures and property abduction. So, we hope you have now understood different types of bankruptcies. Now we'll see the overall procedure. In easy words, a bankruptcy proceeding can be outlined as filing the petition, meeting with the trustee, and settlement of the debt. To understand better, let's break it down step by step. Step-by-step guide to file for bankruptcy. Step 1. Document collection. First, you must collect all your financial documents and credit reports. You must have all the required documents before starting the procedure. Step 2. Credit counseling course. Before filing for bankruptcy, it's mandatory to go through credit counseling. It helps you explore other options before going into bankruptcy, which we'll discuss in a while. You obtain a certificate for completing the counseling services. If you do not take this course, your petition might be rejected, and you may lose whatever you paid while filing the case. Step 3. File petition. The petition is filed to your area's federal judicial district and division. The petition requests relief under one of the bankruptcy codes. You need to fill out some forms to give complete detail of your debts, assets, income, and everything related. You have to file a statement regarding your financial matters and disclose all your creditors and assets in a segment called Schedules. Step 4. Means test. In addition, you need to pass a means test form if you want to file under Chapter 7. In easy words, it evaluates if you have the means to pay the debts. Step 5. Pay the fee. After that, you must pay a filing fee, and the fee depends on the type of code you're filing for. The fee is payable in cash, money order, or monthly installments. If you fail to fill out any form or submit a fee, your case may be dismissed. Step 6. 341 meeting. Next, you'll have to attend a meeting with the creditors, failure of which can also lead to the dismissal of your case. Now, what's the meeting about? The trustee arranges a meeting with the creditors called 341 meetings, as it is required by Section 341 of the Bankruptcy Code. The trustee will verify your identity and will ask you several questions. Creditors are allowed to ask questions if they have any speculations. After this, the case moves to court for further proceedings. This was how you file for a bankruptcy case. However, it is important to discuss it with some expert or hire a bankruptcy lawyer before filing. Consequences of bankruptcy. Bankruptcy might be the only way to wipe your debts and get a clean slate, but it does come with certain consequences. This fresh start might cost you your credit. It stays on the credit report for 7 to 10 years, making it hard to loan money for business or house, even child protection. And then, there's this social stigma that equates bankruptcy with the debtor's untrustworthiness and lack of character. Bankruptcy doesn't necessarily have to be the only way to deal with debts. There are a few other alternatives that should be considered before going into declaring bankruptcy, like out-of-court settlements, reduction of payments, help from consumer credit counseling services, or paying off debts through assets. Before ending the video, let's have a look at a few questions most people have in mind about bankruptcy. First of all, you might wonder who is eligible to file for bankruptcy. Well, anyone who owns a company or a permanent residence in the United States is eligible to file for bankruptcy. However, it is important to pass the means test for Chapter 7, which evaluates your assets. Furthermore, based on previous performance, if the court thinks that you are a cheater, you might not be accepted to bankruptcy. Most people think that all debts are forgivable through bankruptcy. However, it is not true. There are a few debts that are unforgivable no matter which code you file through. These are also called non-dischargeable debts in bankruptcy. These may be some type of taxes, child support or alimony, fines owed to public organizations, and some student loans. So, that was today's video. We hope you got all your answers regarding bankruptcy and how you can file for it. Did you enjoy the video? Please hit the subscribe button, like, share, and comment.